regarding hearing item, that is item 8. The writ appellants are no longer interested in pursuing the matter, so I may be allowed to withdraw this matter, my lord. Item 8, that is hearing item.
Heard Mr. B. Balramenga, learned counsel for the appellant. Also heard who is appearing for the state? Mr. Malhotra, you are appearing for?
I'm appearing for respondents 5 to 12.
Respondent number 5 to 12. As well as who is appearing for the state?
1 to 3, my lord.
Mr.
Samuel Bandarsheta.
Mr. Samuel, learned government advocate.
Additional AG, ma'am.
Oh. Mr. Samuel Bandar Shiata, learned additional AG, appearing for respondent number 1 to 3. Learned counsel for the appellant submits that the appellant is no longer interested to pursue this writ appeal.
Appellants, my lord.
Appellants are no longer interested in pursuing this writ appeal, and therefore he prays for allowing them to withdraw the instant writ appeal. The counsel for the respondent side raises no objection to the prayer. Hence, the prayer is allowed. This writ appeal is dismissed on withdrawal.
One moment.
Much obliged, my lord.
I seek your lordship indulgence in mentioning daily list hearing item number 9, my lord. In this matter, my lord, we are seeking some documents through RTI from the deceased Air Chief, which is relevant in this case, my lord. So the RTI has not been replied till then, my lord. If your lordship might kindly grant some more time for filing of documents.
You are
True,
Mr.
H. Zaudin Sanga, for private respondent number 1, my lord.
Yes.
No objection, my lord.
Heard Mr. T. Lal Zekima, learned counsel for the appellant. Also heard Mr. H. Zodin Sanga, learned counsel for the private respondent, who prays for an adjournment on the ground that the private respondent has sought for some RTI query and same has not yet been received. The government side is represented by
Caroline Kelungakui.
right. The prayer is allowed. Let this matter be
My lord,
listed.
if may be allowed to file by way of affidavit that said document, my lord.
You want to file also?
Yes, yes.
The learned counsel for the private respondent also seeks leave of this court for filing an additional affidavit for bringing on record the said RTI some relevant documents.
Yes.
The prayer is allowed. Let this matter be listed when?
After 3 weeks, my lord.
After 3 weeks.
Much obliged.
Admission item 1.
May it please, my lords. My lords, the formalities, the process of handing over of the said building is taking place, and if your lordship can grant us some time in order to incorporate the handing over.
Which building?
Well, it's not a building, it's a plot of land.
Plot
At
of land.
Lunglai, my lord.
It's a plot of land. Building and
Okay. Heard Mr. Samuel, what is his name?
Vanlal Shriyata, my lord.
Samuel V. Vanlal Shiata Changte, learned additional AG. Also heard Mr. A.R. Malhotra, learned your standing counsel,
Yes, sir.
Guwahati High Court. Learned additional AG Yes, Aizul Bench. Learned additional AG submits that the process of handing over the plot of land to the district judiciary is on, and some time may be granted to the for reporting the for completing the process. The prayer is allowed. Let this matter be listed after 3 weeks.
Deeply obliged.
Yes.
Item 2.
District Judiciary, Lungle.
May it please your Lordship, I'm appearing on behalf of the state respondents, and the matter was last listed on the 21st of May, wherein I was given directions to file an affidavit regarding the outcome and the resolution of meeting which was held on 21/4/2025. In this regard, your Lordships, I am yet to receive any instructions. So if 3 weeks time may be granted to file the necessary affidavit, your Lordships.
Heard Miss Lalnan Louis, learned government advocate, who prays for some more time for filing the. You'll file an additional affidavit.
Yes, your Lordship, it will be, yes, your Lordship, it will be the additional affidavit.
Filing
your
an
Lordship.
additional affidavit for reporting the outcome of the meeting which was held on 21/4/2025 involving PWD, EFNCC, NABARD, Law and Judicial Department and Finance Department. Who is for the, any amicus is there?
No, my lord, I appear for the petitioners in this.
Okay. Heard Mr. Joseph
L. Rentley, my lord.
L. Rintley, learned counsel for the petitioner. The prayer of the government council is allowed. Let this matter be listed after 3 weeks.
Till then, my lord, the stay order passed earlier may continue.
The stay order granted earlier shall continue till next day. Stay order was granted by whom?
1 minute, my lord.
By the court or the forest department? Okay.
My lord-
Stay order shall continue till next day.
Right, my lord.
Item 3.
Your Lordship, item number 3, 4, and 5, a similar matter. However, Your Lordship, I have not yet received the memo of appeal. So this may be taken up after 2 weeks.
Lordship, since they have met the appearance, will serve copies.
See, the copy is received by my client. They are from the other district. They have not yet sent me the memo of appeal.
You furnish the copies?
Will furnish in three of the writ appeals.
No, she is first. You are Miss Dinari, you are appearing for?
I am appearing for the private respondents.
Private respondents, okay.
Your Lordship, I'm appearing on behalf of the state respondents number 10 and 11, and I'm also yet to receive the Paras comments, Your Lordship. So if 3 weeks time may be granted.
Okay. Heard Mr. C. Lal Ram Zoawa, learned senior counsel, assisted by Mr.
Stephen Lalbert.
Stephen Albert,
Sign.
learned counsel for the petitioner. Also heard Ms.
I am for respondent number 5.
Zairem Sanpui, appearing for respondent number 5, and Ms. Lalnan Louis, government advocate, appearing for respondent number
Your Lordship, in serial number 3, it is respondent number 10 and 11. And
For
then,
the state respondent,
yes, Your
state
Lordship.
respondent,
Yes, Your Lordship.
who prays for 3 weeks' time for getting the paravise comment,
Instructions, Your Lordship, instructions.
for getting the instructions. The prayer is allowed. Also, Miss Dinari, what's your full name? Miss Dinari T. Azu, appearing for respondent number 1 to 7, who submits that the said respondents have not yet received the memo of appeal. Learned counsel for the petitioner is directed to furnish the memo of appeal to the private respondent during the course of the day.
Yes, sir.
Let this matter be listed after 3 weeks. In all 3 matters, similar orders.
Your Lordship, since the councils have appeared on behalf of the respondents, notice in respect of all the respondents may be deemed complete. Sir,
As all the respondents have appeared, as the council engaged by all the respondents have appeared, the notice to the respondents is deemed served and complete. Let this matter be listed after 3 weeks.
Much obliged, Your Lordship.
In other items, the respondent numbers are same.
respondent number, private respondents are different. But since the Nanak Council, Srimati
The council are
Dinari, yeah.
same.
councils are same.
Abhishek, cause list से देख लेना, private risk.
Oh, that's item 6.
My Lord, My Lord, I'm for respondent number 1 to 257. My Lord, if I may be given 2 weeks' time to file my objection.
Against the condonation.
Yes, my Lord.
Heard Ms. Zairem Sanpui, learned CGS, Central Government Council, appearing for the applicants. Also heard Ms.
Ruth Lalwat Feli.
Ruth.
Ruth
What is
Lalwat
on
Feli.
Ruth Lalwat Feli, appearing for private respondent number 1 to 257.
Yes, Your Lordship.
She prays 257. She prays for some time for filing written objection against the prayer for condoning the delay of how many days? Prayer for condonation of delay. The prayer is allowed. Let this matter be listed after 3 weeks.
Obliged.
Item 7.
May I please, my Lord? My Lord, in this matter,
Yes.
my Lord, in this matter, my Lord, on the last occasion, my Lord, there was a direction to, my Lord, take steps on the private respondents by registered post. My Lord, however, my Lord, there is a difficulty, my Lord, since these landowners are, my Lord, having addresses with no PIN codes. So, my Lord, therefore, it is not possible for us to, my Lord, take steps by registered post. My Lord, may I pray that, my Lord, we will do service, my Lord, by way of a paper publication, my Lord, in the 2 local dailies of, my Lord, state of Mizoram, any newspaper, my lord, we will take steps by way of paper publication.
How many
Because, my lord-
respondents are there?
My lord, there are 72 respondents, my lord.
You don't have pin.
69 private respondents. My lord, 69 private respondents and respondent number 70 to 73 is the government, my lord, who are represented today. They are already names are shown. My lord, in other cases, similar cases, my lord, we have done paper publication.
Paper publication when they are not able to know, people to report now from the office. That is the same will do.
He's saying that steps cannot be taken.
But they will office not make it go from there. এটা ফেল হলে তেতিয়া যায়
Why you are unable to give the pin codes?
My lord, these are the landowners, my lord, most of them, there is a likely possibility some are there, some are not. And there is every likely possibility that, my lord, the service by registered post is not going to complete and it will ultimately delay the entire writ
No,
appeal.
they will also, postal department will not accept the registered post unless you give pin code numbers.
That is, my lord, because in the original land acquisition proceedings,
Paper
my lord,
publication.
there was no pin code.
Okay.
There is no pin
Okay.
code, my lord. That is,
Heard, Mr. H. Gupta, Lanet. There is a prayer for condoning the delay
yes, my lord. This is an
in the
notice
IA.
was issued in the IA, my lord. Yes.
Mr. H. Gupta, Lanet Counsel for the applicant, who submits that though the applicant were direct was, how many applicants are there? The applicants were directed to take steps for issuance of notice upon the respondents through registered post with AD. However, he submits that in the pin codes of the addresses of the respondents are not available with the petition applicants, and therefore he is unable to take steps for issuance of notice through registered post with AD. He therefore prays for allowing the petitioner to serve the notice on the respondents through substituted mode of publishing the notice in 2 local newspapers of the circulated in the locality where the respondents resides. Considering the difficulties shown by the learned counsel for the applicant in taking steps by registered post with AD, we allow the prayer for issuance of notice through paper publication. The the applicants shall take steps within 7 days for publication of notices in 2 newspapers which is circulated in the locality where the respondents resides. The date of the appearance to be mentioned in the notice would be 25th of July. Let this writ appeal be listed after the said date again.
My lord, may I pay, my lord, 2 weeks time, my lord, to take steps.
Instead of 7 days, 2 weeks times. Okay.
My lord, my lord. Consequently, my lord, the appearance date may also be extended, maybe 5 more, because
Instead of 25th July, make it 31st of July.
I'm highly sure. Obliged.
Finish.
My Lord, if I may make one mention, my Lord, regarding that item number 2, my Lord, I had mistakenly mentioned that there was a stay order, but there is no stay order. So, my Lord, that order, that mentioning the stay order will continue.
Item number 2, Abhishek, stay line to cutting.
That has to be
Okay.
cut. Sorry, my Lord.
Regarding item number 7 of part 2, my Lord, on request of the leading counsel for the appellant, if this matter may be taken up after a week,
Item number 7.
7 of part 2 hearing list.
You have informed the other side.
Yes, my Lord, I have taken the consent.
Heard Ms. Ruth Lalruat Feli, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed the counsel for the other side regarding her prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed after
A week.
a week.
Obliged.
My Lord, I would like to make a mention in part 2, item number 9. I'm standing on behalf of my senior, and I have already taken the consent of the other party. So like if the matter could be listed after 2 weeks,
On what ground you are seeking adjournment?
like I've taken the consent of the other party, like my senior is not feeling well.
Consent is a different thing. There must be some ground for seeking adjournment. Consent is you are informing the other side that you are seeking adjournment. But you must satisfy the court that there is a valid reason for seeking adjournment.
Like
What is the ground?
like my senior, he's not feeling well, and
Yes,
even the
that
other.
may be a ground. Heard, what's your name?
LK Mangaizwali.
Heard Miss L.K. Mangaizwali, learned counsel for the appellant, who prays for an adjournment on the ground that on the ground of personal difficulty of the conducting counsel for the appellant. Learned, who is the PP?
Miss Mary.
You have informed.
Yes, my Lord.
She has submitted that she has informed the learned additional public prosecutor regarding her prayer for adjournment, who has no objection to the same. Hence, the prayer is allowed. Let this matter be listed after 3 weeks.
Obliged.
Admission, item 1.
Your Lordship, item 1, I seek your Lordship's indulgence. I have some personal difficulty today. If this matter can be taken up on the 23rd, coming Monday.
Okay.
I
I have no objection, my Lord.
Heard Mr. A.R. Malhotra, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. Stop. Learned counsel for respondent number 1 to 3 has raised no objection to the prayer made by learned counsel for the petitioner. Hence, the same is allowed. Let this matter be listed on 23rd June 2025.
I'm open.
Item 2.
Lordship, in the last court order dated 13/6/2025, I was allowed to submit the written instructions from the department regarding Lordship, the respondents number 1 to 6 will be represented by the Commissioner, CGST Aizawl, Lordship. Lordship, this is the written instructions which I have received from the department, Your Lordship. Serial number 2 is the operative, Your Lordship. Paragraph number 2. The Commissioner in whose name authorization is hereby issued on behalf of the respondents, Zone CGST and CE Guwahati, Commissioner CGST and CE Aizawl. Lordship, in this writ petition, there are as many as 7 respondents. Also, 7 respondents are available in this writ petition, and I have already filed the affidavit in opposition on behalf of respondent number 7. And may take Lordship to page 4 of the writ petition, Your Lordship. Name of the respondents are reflected here. Page 4 of the writ petition.
Yes.
Number 1 is the Union of India represented by Secretary to the Government of India, Ministry of Finance. And number 2 is the Union of India represented by Under Secretary to the Government of India, Revenue, Ministry of Finance. And number 3 is the Chairperson, CGST. And number 4 is Chairman, CBIC. And number 6 is GST Network represented by Chairperson, Ministry of Finance. And number 6 is Commissioner, Joint Secretary in the Central Board of Indirect Taxes and Customs. Lordship, this respondent number 1 to 6 has authorized the Commissioner, CGST and CE Aizawl to represent them, Lordship.
Joint Commissioner is the number 7.
Yes, Lordship. Joint Commissioner, CGST, I have already filed affidavit in opposition, Lordship.
On behalf of number 7.
On behalf of number 7. Also.
1 to 6.
1 to 6. That 1 to 6 has authorized the Commissioner, CGST and CE.
Who is representing them? Who will be representing?
As the council is him.
Yes, no, sir. Representing, I mean, like they have to file affidavit of opposition.
No,
on
why
behalf
this
of
query was posed?
Lordship, the reason was that since the
My lords, this query, I have to
Commissioner-
clarify, this query is not posed from this honorable court. It is actually, my lords, the council who is now seeking that they file a counter. A coordinate bench, my lords, Itanagar, my lords, this honorable court, similar matters, has disposed of such matters. I have those orders, my lords. They are trying to protract these proceedings. The writ petition was filed in July of last year, my lords. The counter affidavit of respondent number 7 came early this year, sometime this year. During such time, my lords, never have they reached such a thing, my lords. And this instruction he is getting from the department, not from the court, my lords.
No, Lordship, that order which I have received is from the respondents number 1 to 6, Your Lordship. And the problem is, Your Lordship, the Commissioner, CGST and CE Aizawl is not a party herein, Your Lordship. So this writ petition is, Lordship, since the Commissioner is not the party herein, Your Lordship, so he may be impleaded as a party or otherwise being the head of the department in the Commissionerate, Lordship. This writ petition may not be maintainable, Your Lordship.
Why?
Because the Commissioner is the head of the department, then that has to be represented by the CGST Commissionerate Aizawl, Your Lordship.
No, where is the error? Union of India is represented by Secretary. That is
And Your Lordship,
as per law.
Respondent 6, Commissioner. This is the central board.
Central board, Your Lordship, yes.
Such a
Number 2 is
hyper-technical.
okay. Number 3, Chairman, Ministry of Finance. What is this Chairperson, Ministry of Finance?
My lords.
Number 3,
Yes.
GST Council
Yes, yes,
represented
my
by Chairperson.
Chairperson, my lords.
Chairperson of the GST
GST
Council.
Council. My lords, they make all the rules and regulations, my lords, whatever recommendations come, so that the GST
acts are implemented in a smooth manner. And your lordships,
Now, what is your prayer?
Lordship, my prayer is that I may be allowed to file the affidavit in opposition on behalf of respondent number 1 to 6. That will be testified by the commissioner, CGST and CE, Aizawl Commissionerate, Lordship. But the problem is, since the commissioner here in Aizawl is not a party herein, that may be a problem, Your Lordship. If Your Lordship allow us, then we can file the affidavit in opposition, Lordship.
your lordships, can I just take your lordships
So
through one
that's,
page? One page.
So he may be a party in this writ petition, Your Lordship. So he is the necessary party. He is the head of the department. So he needs to be implemented in the writ petition, Lordship. This is my humble understanding.
And if your lordship sees the earlier orders of this court during these proceedings, this is the first time, my lords, at such a late stage, such a submission is being made. Not even in the counter they've raised anything like this, of this sort, of Respondent 7. Who is the one who has issued the order we are challenging? Covered matters, my lords, it can actually be disposed of.
No, let them file counter. We'll give short date.
Lordship, yes.
Heard Mr. Jordan, Roming Thanga, learned counsel for the petitioner. Also heard Mr. Johnny L. Tochang, learned counsel for the respondents, who submits that the respondent number 1 to 6, the Commissioner CGST and C Aizawl is authorized to represent respondent number 1 to 6 in this case, and to that effect he has produced a photocopy of correspondence dated 7/8/2020. Now, this is 7/8/2024.
Lordship, yes.
Why are you informing
Lordship,
this court so late?
This letter I have received only on 13/6/2025, which is last week.
7/8/2024.
Yes.
Learned counsel for the petitioner, learned counsel for the respondent submits that though the respondent number 7 has filed his affidavit in opposition, but respondent number 1 to 6 are yet to file the same.
Yes, Lordship.
And he seeks some more time for filing the same.
Lordship, yes.
The prayer is allowed. Let this matter be when?
Lordship, after 2 weeks, Lordship, within the
Let this matter.
My lords may put it 3 weeks so that it can be
Yes.
no further time may be taken.
Let this matter be listed after 3 weeks.
3 weeks, Lordship.
Your lordships, do one thing, my lords. The interim stay, my lords, that may be extended. That was passed on 19 July 24. It was extended. But on the last date,
The interim order passed on 19/7/2024
yes,
shall continue till next date.
No problem.
my lords, one last, since your lordships has allowed the prayer of them to file a counter, my lords, I may amend the cause title also. That will
For
be
bringing
correct.
the commission.
Yes, I'll make them part.
In view of the submissions made by learned counsel for the respondents, that respondent number 1 to 6 are authorized to represent, are represented by the Commissioner CGST Aizawl. The learned counsel for the petitioner seeks leave of this court to amend the cause title of the writ petition to that effect. The prayer is allowed. The said the amended cause title shall be filed before this court before the next date fixed. List accordingly.
Grateful.
Item 3.
Lordship, this matter was placed before Lordship yesterday. Because of the inconvenience on the part of the counsel for the respondent number 1 and 2, matter has been refixed for today. Lordship, in connection with IA 76 of 2025, arising out of RFA number 1 of 2025, the applicants are seeking for direction.
Just a minute. There is a IA.
Yes, Your Lordship.
Yes.
Whether Lordship is on IA?
Yes.
Lordship, if I take a Lordship to the enclosed annexures, apart from the...
In the IA?
Yes. Impugn judgment and order. Lordship, may I go to Annexure 2 at page...
You refresh my memory. What is the facts? What are the facts?
Yes, Your Lordship, there's a dispute over the location of the land settlement certificates.
Overlapping is there.
Overlapping. There appears to be some overlapping. And the matter was adjudicated by the Learned Trial Court, and the appellants were the defendants number 1 to 4, in which the present respondents were the plaintiffs. Respondents number 1 to 5 were the plaintiffs. And in the meantime, during the pendency of the suit, transaction was made in respect of one of the lands covered by the 625 of 2005, which was then belonging to the plaintiff number 5. And now the plaintiff number 5 had sold the said portion of the said land to the respondent number 5A, who was not a party in the trial court. 5A has been subsequently impleaded. And even during the proceeding of this appeal, though appeal has been admitted and stay has been granted, the respondent number 5A, who was rated as opposite party number 1 in this connected IA, she continued to make construction over the disputed land. And Your Lordship, if I take Your Lordship to Annexure 2, page 45. This is the first IA which we had filed. It is IA Civil 65 of 2025. IA Civil 65 of 2025. Has the Lordship got it?
Yes.
At page 45. The parties are the 4 appellants have been shown as the applicants, and the respondents number 1 to 5 were also shown as opposite parties, 1 to 5. And if I take Lordship to para 3, may I read this order, Lordship?
What is this order? What
This order is an order in connection with the first IA, in which the applicants had sought for a direction for interim injunction.
What was the outcome of the
Outcome of the order, the application is that since the order was supposed to be directed against the person who had purchased the land, who was not a party at that point of time, then this honorable court had made direction that the matter cannot be adjudicated in such a manner in the absence of 5A.
So I was dismissed.
Yes, I was dismissed.
Okay.
Your Lordship, in this
Thereafter you
connection,
included the 5A as party.
yes, Your Lordship.
Okay.
At para 5, at page 49 of the order, may I read?
Yes.
May I read?
Yes.
The Learned Council also submits that, in fact, it is not the respondent number 5 who is making the construction, but Srimati Jubilee E. Chauhan, to whom the land was sold. He submits that since she is not impleaded as a party to the instant application, no effective order can be passed. He further submits that doctrine of least pendants has not been raised in the application, and therefore, submissions made by the Learned Senior Counsel in this regard beyond the pleadings. He further submits that transfer of property will have no application. And para 7, discretionary powers being conferred upon the court under Order 39 Rule 1 CPC for grant of temporary injunction, the same can be granted by the court upon being satisfied that there is a prima facie case in favor of the applicant, irreparable injury likely being caused to the party concerned, and there being balance of convenience in favor of the applicant without delay and latches. All these factors should be available to attract the grant of temporary injunction. However, in the instant case, the respondent number 5 is said to have sold his land to Srimati Jubilee E. Chauhan, and as admitted by the parties, constructions on the sued land is being made by her. She being not a party to the instant application, it would not be possible for this court to pass any effective order of restraint indirectly through another individual. So, we have enclosed here at Annexure 3, the factum of the construction by which we have taken the photographs. These photographs were dated 28/4/2025 and 13/5/2025. There's been some development even in between. And thereafter, we had approached this honorable court by filing the impleadment application. And
what was the number of the title suit?
Title suit is
where you were defendant.
40 of 2014.
And when the judgment was passed?
Judgment was passed on 17/10/2024.
The suit was decreed.
Decreed.
Against which you are on appeal.
Yes, yes, Your Lordship. May I take a Lordship to the portion, the operative portion of the decree?
Yes.
Which is there at page 44. Para 18.
Yes.
The competent authority, that is Land Revenue and Settlement Department, shall, within a period of 3 months, make necessary rectification with respect to the overlap portion of the LSCs of the plaintiffs by that of the LSCs of the defendant numbers 1 to 4. Additionally, the competent authority may, since it had been found that the LSCs of the defendants number 1 to 4 are also valid at this stage, explore alternative remedy by means of allocating alternate lands to the defendant numbers 1 to 4 if, after proof of verification that the conditions and mode of issuance of LSCs to the defendant numbers 1 to 4 was done following due procedures of law. This process shall also be completed within 3 months of the date of this judgment and order. So, Your Lordship, by this order, the appellants were supposed to seek for some other lands which are to be allotted to them by the Revenue Department, since as per the decree of the trial court there has been some overlapping, and since the LSCs of the plaintiffs, who are the respondents here now, were found to be prior in time than those LSCs of the appellants for the defendants. So this direction, this decree was passed, and Your Lordship, the challenge was made in respect of those the decree because of the fact that there was never any such overlapping in respect of the original P patas. P pata means periodic pata, in respect of the lands of the plaintiffs, the land belonging to the father of the plaintiffs, and the father of the defendants, 1 to 4, were the appellants. So, in fact, since there was no overlapping of the P patas, there could not have been any overlapping of the LSCs, which were made on the basis of those P patas. And a clear boundary line was drawn in respect of those P patas. And the P pata of the appellant's late father was prior in time than the P pata of the late father of the plaintiffs.
So you are submitting that the trial court held wrongly that
Yes.
periodic pata of the plaintiffs were in prior in time.
Yes.
That was a wrong finding. Of
P
fact.
patas, so far as P patas are concerned, the learned trial court did not make that finding. Only thing is that since the LSCs, land settlement certificates, made and issued on the basis of those P patas, it was those LSCs of the plaintiffs were prior in time than the land settlement certificates of the appellants. So that's the only reason why they have been directed to be sifted out.
Then thereafter, respondent number 5, the plaintiff number 5,
Yes.
alienated his share,
Yes.
his portion of land to plaintiff.
During the whole course
to-
of the proceeding of civil suit, no such thing was said. The plaintiff number 5 continued to be the plaintiff number 5 due to the fact that the document regarding the transaction, the sale of his property to Srimati Jubilee E. Chuaha has been shown. But he continued to represent the interest of Srimati Jubilee Chuaha. Because as per the Transfer Property Act, which as already held by this Honorable Court, would, if applied, the matter will be governed by the principle of lease pendants, because it was a transaction made during the pendency of the suit. But the view adopted by this Honorable Court in connection with the earlier IA 65 of 2004 2025 was that since Transfer of Property Act would not be squarely applicable, then the question of
What
applying-
would be applicable? What principle would be
At
applicable?
least the principle will apply.
What is the principle?
The principle apply. Otherwise, my lord, it will not be
No,
possible
my
to.
query is what principle would be applicable?
The principle will be that since it has been sold during the pendency of the suit, then instead of not requiring the plaintiff number 5 to abandon or to implead the person in whose favor the land has been sold. The suit was proceeded on.
But ultimately in the suit, it was decreed in favor of plaintiff number 5.
But plaintiff number 5. And on the basis of the decree,
So what is your prima facie case in this interlocutory application?
yes, this
The respondent number 5A is a bona fide purchaser.
5A is a bona fide purchaser. Yes. And
So
now,
why to stop her from constructing land?
now that in
House.
her absence, yes, in her absence as a party, it will not be proper. That was the view of
Who
this
is
honorable
it?
court.
Who is
And now
representing
she has been impleaded. Now that she has been impleaded as respondent number 5A, she is now present, and in connection with the application under IA 77, C77 of 2025, impleadment was sought for arraying the buyer, that is Srimati E. Chua as respondent number 5A, and it was allowed. And now she is a party at this stage.
Okay.
She is a party at this stage, and after that we had filed this application under 76 IS 76 of 2025 under the same provision of law, that is Order 39 Rule 1 read with 151 CPC. Your Lordship, by an order dated 8/5/2025, which I have enclosed at page 53 of this application. The order portion is at page 54.
Yes.
Learned Counsel, assisted by Mr. So-and-so, Learned Counsel for the appellant. Also heard Mr. Z. Ricky, Learned Counsel for the private respondents, and Caroline so-and-so. Having regard to the submissions made by Learned Counsel for the parties, it is hereby directed that, pending disposal of the appeal, the impugned judgment and order dated 17/10/2024, passed by the Court of Civil Judge, Senior Division 4, Aizawl, in civil suit number 40 of 2014, shall remain state. So the impugned judgment and decree has been stayed by this order, by this honorable court, by its order dated 8/5/2025. So my humble submission at this stage is that, my Lord, since the dispute remains a dispute between the parties, and when the matter is before this honorable court, it will not be fair on the part of the respondent number 5 or even any other party for that matter to make construction or to continue to develop the suit land.
What relief was sought for in the title suit?
Relief was for
declaration.
Yes, Your Lordship. At page 31 of the RFA 1 of 2025, we have enclosed the plaint of the respondents number 1 to 5 in civil suit number 40 of 2014.
Page number?
Page 31, starting from page 31. At the bottom, relief spleen. 32, Your Lordship.
Page 32 of the IA.
No, not IA. I'm now turning back to the RFA. May I read, Lordship?
Declaration and recovery of possession.
Yes.
So you were not in possession.
For a decree declaring the plaintiffs are the rightful owner of the portion of the lands covered under LSC number so and so, on which are overlapped.
So the land was not in your possession. It was in possession of respondent number 5.
No, it was in our possession.
Then why you sought for recovery of possession if it is?
No, they had sought for recovery of possession because the plaintiffs had sought for recovery of possession.
So it was not in your possession.
It was not in the possession of the plaintiffs. We are the defendants.
Okay. It was in your possession.
Yes.
Then when it was handed over to the possession of?
It was not handed over because they had simply taken over possession on the basis of the impugned judgment and decree. In spite of strong protest, they said, the moment there is a stay order of this judgment, we'll stop. And if necessary, we'll demolish everything. And with that, they continued, in spite of our objection.
You have stated that in your injunction petition?
Yes. What I have stated in my at page 5 of the application, IA application, may I take Your Lordship to page 5, paragraph 4 of IA 76.
Yes.
In paragraph 3, I have stated that at this stage, it may be stated that the plaintiff number 5, opposite party number 2, though had already sold the land covered by LSC number 625 of 2005 to the opposite party number 1, Srimati Zubili Ichuoha, Ramnun Aizol, in the said civil suit. The name of the previous owner has been shown as plaintiff number 5. 4. That since construction of an RCC building has been started and continued over one of the lands in dispute, that is LSC number so and so, that is 1099 of 2010, in the name of the applicant number 1. The ownership of which was also claimed by Sri Laldong Liana, opposite party number 2, under LSC number 65 of 2005, in the connected civil suit 40 of 2014. The applicants had earlier filed IA C65 before this Honorable Court for grant of temporary injunction under Order 39 Rule 1A, read with Section 151 CPC against the opposite party number 2. However, the said IA was rejected by this Honorable Court by its order dated 8/5/2025 on the ground that respondent number 5 in RFA 1 of 2025 is said to have sold his land to opposite party number 1, Srimati Jubilee E. Chauhan, and that she being not a party to the IA Civil 65 of 2025, this Honorable Court had held that it would be impossible for the court to pass an effective order of restraint indirectly through another individual. The order which I have read out has been annexed, Your Lordship. Para 5. In view of the order dated 8/5/2025 and submission of the Land Council for the respondent number 5 that it is not the respondent number 5 who is making the construction, but Srimati Jubilee E. Chauhan, to whom the land was sold. Applicants are now approaching this Honorable Court once again for grant of interim injunction under Order 39 Rule 1A, read with Section 151 CPC against opposite parties. 6. That as on today, construction of the said RCC building over the land in dispute has been progressing day by day and has been pursued by the opposite party number 1 with full force. In fact, on 28/4/2025, the applicants had gone to the building site and had taken photographs of the ongoing construction, which was earlier endorsed or annexed in IAC 65 of 2025. As on today, there has been some development in the construction of the said RCC building, as can be seen from the photographs taken on 13/5. That all the landed properties covered by the 4 LSCs, such as have been in the possession of the applicants till date. However, in respect of the land covered by 1099 of 2010 belonging to the applicant number 1, the opposite party number 1 has been making unauthorized and illegal construction as stated above. Thereby, I have stated that all the lands in dispute, which are 4 in number, they were in the possession of...
Your position.
Yes, the applicants. Except this LSC, which is under 1099 of 2010. This is also given the number 625 of 2005 in the name of the opposite party number 2, Sri Naldong Liana, and subsequently opposite party number 1, Srimati Jubilee E. Chauhan. Now, that by making illegal development of the land in dispute by constructing the said RCC structure stated above by the opposite party number 1, the said property in dispute in the connected appeal is in danger of being damaged or alienated by the opposite parties without any authority while the matter is before this Honorable Court in appeal in RFA number 1 of 2025. Para 9. In spite of the impugned judgment and order dated 17/10/2024, the appellants or applicants have a strong prima facie case in their favor, and the lands in dispute having been in the possession of the applicants till date, except for the land under LSC number 1099 of 2010, which has been shown as being purchased by the opposite party number 1 from the respondent number 5, opposite party number 2, during the pendency of the civil suit number 40 of 2014, on which the opposite party number 1 has been making a said unauthorized or illegal construction. Balance of convenience is in favor of the applicants. Further, the dispute is of a nature in which adequate monetary compensation cannot be given to the applicant number 1. In fact, void order dated so and so passed in RFA number 1 of 2025. This Honorable Court was pleased to admit the said RFA and had directed that pending disposal of the appeal, the impugned judgment and order dated 17/10/2024 passed by the Court of Civil Judge Senior Division shall remain stayed. So, if no interim injunction is passed at this stage, Your Lordship, there's a possibility of the construction going on. And even if the matter is reversed, supposing this Honorable Court makes a decision against the
If
plaintiffs,
it allows the appeal.
allow this appeal, then it will be very difficult for even the court to make execution of the order or implementation of the judgment of this court.
Why
So-
you take the building also along with land?
Yes. At the same time, it will not be fair even on the part of the respondents to continue and to develop the sued land while the matter is in session before this honorable court and while the appeal is pending. And there's a strong prima facie case in favor of the applicants, and balance of convenience is also in favor of the applicants in view of the fact that stay has been granted and possession was forcefully taken over from the possession of the applicants.
Where is that statement? That possession was, you are only saying that all lands are in your possession except this one.
Except this.
When this land when you were dispossessed of this land? Or which one is
it was on the basis of this judgment and
Where
order.
is the date? Where is the statement?
That is 17/10/2024, Your Lordship.
Where? No, when you were dispossessed of the land over which respondent number 5A is now constructing her house. Because transfer was during the pendency of the suit.
Yes. And transfer was during pendency of the suit, and now, what I have stated in para 4, let me read it again. Since construction of our RCC building has been started and continued over one of the lands in dispute, that is LSC number 1099 of 2010.
No, here you have not specified.
I have not specifically stated that it was taken over on such and such date. But what I have stated is that all the lands were in the possession of the applicants.
Except
However,
this one. Except
yes.
this one.
However, as on today, because she is making construction, I cannot say that this is in my hands now. And what they have sought for in the suit is also...
She will say that since the date of purchase, this land is in my possession.
She was not in possession because even in the title suit, in the connected civil suit 40 of 2014, what they have sought for is for recovery of possession, which was granted to them by way of the impugned judgment and decree. The fact that it was not in their possession is clearly indicated even by that very fact. So only on the basis of this impugned judgment and order, she had come forward, made construction, and initially we were not aware. We were not aware of such acts or actions taken by her because she was not a party. The party was Mr. Laldong Liana, plaintiff number 5, who has been arraigned as respondent number 5 now. And when we inquired, we were informed that it was already purchased by Srimati Ichwaha. And we were under the impression that since she had started construction, we had sought for a direction of this Honorable Court to direct her by way of interim injunction to stop doing all such activities within the suit line. But since she was not a party,
Okay, that aspect is okay.
so that was the reason why we have approached this again, this Honorable Court again, by filing impleadment application in which she was impleaded as respondent number 5A, and we have sought for the similar direction against her by way of this application. Lordship, the very purpose of filing the appeal, so far as respondent number 5A will be all infructuous if she is allowed to continue construction. And we are not saying that she should demolish the building as of today, but that she should not continue in the interest of justice.
What is the difference?
Difference is that, Your Lordship, if she makes
Now suppose
she is continuing.
suppose your appeal is allowed, what will happen to the
there's a
building?
possibility of negotiation.
That possibility remains even if the building is complete.
That is true. But even in the face of the matter being adjudicated by the Honorable Court, if she is allowed to continue, it is up to the Honorable Court. The matter needs to be brought before the Honorable Court, and in spite of all this, if the Honorable Court is of the opinion that let her continue, it is up to the Honorable Court. We have nothing to say. That possibility of negotiation is still there, but it is the duty, the bounden duty of the applicants to bring this matter before the Honorable Court, saying that since she has been making construction in spite of the fact that stay has been granted even in respect of the impugned judgment and decree, if she persists, and if she is allowed to persist in making construction, my Lord, I have nothing to say.
Yes. What is your name?
J.H. Rikilal Botfela, my Lord. My Lord, my Lord, in regards to IA number 76 of 2025, I have submitted my affidavit. And in regards to the submission made by the Learned Senior Counsel, my Lord, I would just like to make some few submissions regarding to the constructions which have been submitted by the Learned Senior Counsel. My Lord, if I may take you to my affidavit in your position. Page number 5, my Lord.
Yes.
My Lord, the relevant page is at page 5, and the relevant point is point number 8, para number 8, my Lord.
Yes.
My Lord, if I may read out.
Yes.
That with regard to the averments made at paragraph number 7 and 8, the answering respondent number 1 and 2 would like to submit that the construction in question was not illegal. In fact, after the judgment and order dated 17 October 2024, passed in civil suit number 40 of 2014, which was in favor of LSC number 625 of 2005, the construction activities were lawfully carried out in accordance with all applicable provisions and permissions. The construction was undertaken only after the rights of the LSC's holder had been conclusively adjudicated and established by the competent court. Thus, the construction was effected strictly in conformity with the law and the judicial mandate, and there is no infirmity or illegality in the said construction.
But now stay has been granted.
My Lord, the stay has been granted only as per the decree. My Lord, the stay is nothing relevant to the constructions, my Lord. The stay is to reallocate the site of the appellant.
No, stay is on the decree.
Stay is for the decree, my lord.
For the decree, where decree is also for the declaration of the rights of the plaintiff over the suit land
My lord, there is not mentioned, my lord.
in the decree.
Yes, my lord.
Okay.
So further, my lord, at point number 9, may I continue, my lord?
Yes, yes.
That with regard to the affirmance made at paragraph number 9 and 10, the answering respondent number 1 and 2 would like to submit that there is no prima facie case in favor of the applicants. It is respectfully submitted that a commission verification report dated 21st April 2023 and last and final demarcation reports dated 27th October
No,
2023.
you purchased the land during the pendency of a civil suit,
Yes, my lord.
knowing fully well that your seller from whom you purchased, that is plaintiff number 5, may or may not get the land.
My lord, in that regard, the respondent, the buyer, have no knowledge regarding the suit land during that time.
Okay.
My lord, may I continue?
Yes, yes.
Last and final demarcation report dated 27 October 2023 was duly prepared and annexed.
Now you have to address me also.
Yes, my lord.
Suppose the appeal is allowed, what will happen?
What will happen is that as per the order given in the trial court, my lord, the land will be, as per the reports as well as the reports of the last and final demarcation reports, my lord, there was no overlap. The findings of the surveyor and the commissioner, there was no overlap. But in the decree, it has been given that the respondents, but the appellant herein, they were given to be relocated the land in a different area as per the decree, my lord. If I may read out the decree, my lord. There is in IS 76, my lord.
Yes,
page 44. Para number 18, my lord. My lord, if I may read out.
Yes, yes.
The competent authority, that is the Land Revenue and Settlement Department, shall within a period of 3 months make necessary rectification with respect to overlap portion of the LSCs of the plaintiffs by that of the LSC of the defendant numbers.
No, this is the order of the court.
Yes, my lord.
Suit is decreed without cost. So, as per this order, decree has to be prepared. And the suit, when the court directs that suit is decreed, all reliefs are decreed. One of the relief was for declaration of right title and interest of the plaintiffs over the suit land. So that is also decreed. Now suppose the decree is reversed, the appeal is allowed.
Yes, madam.
And you continue to construct your building. Are you ready to hand over the building to the present appellant?
My lord, in my humble opinion, if this appeal was admitted, and actually coming back to the history of the trial in the civil suit, my lord.
We are concerned about the present this interlocutory application regarding injunction.
My lord, it will be
whether to
impossible to
injunct
hand
you
over.
from further constructing.
My lord, it will be impossible to hand over.
On that aspect, with that, in respect of that matter only, I am putting my queries.
My lord, it will be impossible to hand over.
So
since the construction
then you
has been
stop
made legally.
constructing. If it is not possible to hand over, then you stop further constructing. Wait for the outcome of the appeal.
My Lord, as of now, there are in the construction, while the construction is going on, so they have stocked up cement and all those things. So it will be damaged.
Okay.
So that will cause a loss of...
Okay, what else is your submission?
My Lord, if I may continue with my submission, my Lord.
Yes.
Last and final demarcation reports dated 27 October 2023 was duly prepared and annexed to the records. At no stage was the Commission verification report dated 21st April 2023 and last and final demarcation report dated 27 October 2023 were ever challenged, objected to, or controverted by the applicants, defendants, or their counsels. Furthermore, the applicants in the civil suit has never initiated any proceeding to examine or cross-examine the Commissioner regarding the said two reports. The main appeal filed by the applicants is completely silent on any challenge to the Commission verification report dated 21st April 2023, as well as the last and final demarcation report dated 27 October 2023, nor does it reflect any effort to discredit or rebut the findings contained therein. In the absence of any such challenge, the Commission verification report dated 21st April 2023 and 27th October 2023 remains unshaken and stands as an unimpeached...
What this report says?
My Lord.
21, that there is no overlapping.
Yes, my Lord.
Then whether the impugned judgment took into consideration this report, because this is prior to the judgment delivered in...
Yes, my Lord.
Judgment was on 17/10/2024.
Yes, my Lord.
So whether it was taken into consideration?
This report was taken into consideration, and with this report, judgment was passed.
How it can be?
My Lord,
if this report is saying that there is no overlapping.
My Lord, there was no overlapping, but with the final report, that is 27th October.
Yes.
In the final and there is last and final demarcation report, there is 27 October. There is some findings that there is some overlap. But
So
due
there
to the
was
sellers,
overlapping.
but it was not confirmed, my Lord. So it was never challenged. My point was that it was neither cross-examined nor challenged, my Lord.
No,
So
what you want to say?
Therefore, my Lord, the applicants cannot now be permitted to dispute the findings of the commissions, as well as...
No, what this 27 October report says, that there was overlapping.
My Lord, I'll come to that, my Lord. My Lord, if I may take you to page number 28 of my affidavit in opposition, my Lord. This is the reports of the final, last and final demarcation reports, my Lord.
What it indicates?
28, my Lord, page.
Yes.
28.
What it says?
The relevant point is at page 20, point number 2, my Lord. Examination of the land. If I may read out, my Lord.
Yes.
Based on the LSC report given previously on the overlapping World Bank Road of Mr. VL Huabzawa versus SOM and others of the LSCs and the land, it was carefully measured. The owner of the LSC recorded the measurement of the land for width. However, some landowners have not recorded carefully. The overlapping of the land was clearly explained. There could be carelessness from the LSC seller. So this reports, my Lord, is somehow it has mentioned that there is some carelessness from the LSC seller. But with this report,
yes.
With this report, my Lord, there is only mentioned that there was some overlapping. So with these reports, there was a degree that they overlapped land has to be rectified and given in, to be given in another area. So with only this report, there was confirmation that there was overlap. My point is, my lord, these reports have never been challenged in the trial court. The first reports were never been challenged. The commissioner was never cross-examined. And in fact, the LSCs...
No. Where is that explanation when the commissioner says that the overlapping of land was clearly explained?
In the commissioner report, there was written, it is written, there is in page number 17.
Page number?
17, my lord. The conclusion, point number 5.
Yes. Please read.
Yes, my lord. It is evident that there was overlap of the 4 LSCs of the children of Mr. Zamanthanga late and the 5 LSCs of Mr. Walkhuma late. The 4 LSCs of Mr. Zamanthanga legal heirs are towards the World Bank Road they have occupied after the P. Bata conversion. His legal heirs have sold the land and the purchaser of the land have built a house and have rented it out to tenants. The northeastern corner LSC was divided into 2. However, this is not shown in the rough map. Nonetheless, Mr. Walkhuma late legal heirs have not contributed from their end towards the area near the World Bank Road. The issue is with the matter of the overlap of the 5 LSCs. As per the rough sketch, the 5 LSCs did not totally overlap. The report is submitted for further necessary measures required. So here at the end, as per the rough sketch, the 5 LSCs did not totally overlap, my lord.
Okay. Okay, now what is your submission?
My submission is, my lord, I will continue.
Yes.
Accordingly, there is no prima facie case in favor of the applicants for the grant of temporary injunction, my lord. Since there is an absence of such challenge, the Commission verification report dated 21st April 2023 and 27th October 2023 remains unshaken and stands as unimpeached piece of evidence on record. Therefore, my lord, the applicants cannot now be permitted to dispute the findings of the Commission, and in the absence of the credible challenge, the report must be accepted as conclusive, my lord. That is my submission, my lord.
Okay. State has anything to say? State is not.
Lordship, we have not implicated state in this particular application, though they are a party in the RFA number 1 of 2025, because we have not asked for anything to be done by the state in respect of the construction or demolition or whatever.
You have anything to say in reply?
Lordship, so far as the report is concerned, the report is there taken into consideration in the impugned judgment and decree, which we have challenged. Simply because we have not stated that the verification report of Mr. So-and-so is wrong and cannot be acted upon, that does not mean that since the matter has been taken into consideration by the learned trial court, when we challenge the validity or other ways of the said impugned judgment and order, it is all included. So it cannot be said that just because that particular fact has not been mentioned, it cannot be said that there is no prima facie case. And also, it was stated by the learned counsel that the respondent number 5A, who has been implemented as OP number 1, did not know that there was any such case before she purchased. But it is the principle of law that a buyer should be aware of all such things. Buyer be aware is the cardinal principle in respect of sale and buying of properties. So even if she is not aware of dependency,
When you started construction after the decree was passed in
I believe so,
Title
my
Suit
lord.
14,
I believe so.
only after that.
Yes, my lord. It was something around that.
So by
I
that
don't-
time you were knowing.
My lord, I don't exactly know I cannot exactly specifically say the date on which
No,
month.
but you have taken a plea in your.
Yes, my lord, but the
in your-
construction as it seems that it was, I haven't asked the date of the
No,
construction.
one of your plea is that once you are assured that decree is passed in favor of your purchaser, thereafter only you started constructing.
Yes, my lord, as per the procedures, when all the mutation of the LSCs
So
have been made.
by before starting construction, you were knowing about the litigation, even if earlier you were not aware
Was not aware during the purchase.
during the purchase, but before starting construction you were knowing. Yes or no?
My lord, I
You
cannot
have-
answer that because I
No,
haven't
you have
communicated with that
indirectly
topic.
stated so in your.
My lord, I have mentioned that in my affidavit that as per the provisions we have done everything
Okay,
legally. So that is all.
Okay. State has anything to say? Though no relief is claimed.
We have not filed or said anything, my lord, in this
Okay.
matter.
What will happen in the main appeal?
in main appeal, Your Lordship, case record of the Nanad trial court has been
Has
called
not
for.
yet.
It is placed before Your Lordship.
Has been received.
Yes, yes,
So the matter is ready for hearing.
it is. Paper book may be required because of a number of evidence. Some are in the vernacular. Direction may be made for preparation of paper
In
book.
main appeal, heard Mr. C. Lalram Zoawa, learned senior counsel assisted by Mr. Stephen Lal Buat Saiha, learned counsel for the appellants. Also heard Mr. Samuel Vanlal Shiata, learned additional advocate general, appearing for the state respondent, as well as Mr. J. H. Ricky Lalrot Fela,
Yes, ma'am.
appearing for respondent number 5 and 5A.
Yes, my lord.
5 and
In
5.
fact, Your Lordship, he's representing
One-
all the respondents,
All the
all the
respondents.
private respondents.
all the private respondents. All the private respondents. The where is the note that records have been received? It is there. Okay. As the records of the trial court has been received, the registry to prepare paper book and list this appeal for hearing after preparation of the paper book. As regards the stop. As regards the interlocutory application, I will pass orders in chambers today.
All right.
Today.
Obliged, my lord.
Item 4 to 18.
This, give it to me in my chamber.
Your Lordship, all these matters are more or less analogous in the sense that the parties are having their different plots of land at various places along the national highway, which were taken over by way of acquisition. They were paid their land compensation. And what has been sought for in this batch of writ petitions is for payment of relief and rehabilitation, which has been assessed by the state government. But since that assessment was not accepted by the central government, which has made construction of the national highway on the basis of a fund made available by the Japan International company, JICA. And in view of that, all these writ petitions have been put together because they are more or less analogous. Since the JICA format and the assessment is much lower than that assessed by the state government in accordance with the Land Acquisition Act of 2013.
You are seeking compensation from the union government?
From the respondents who are state authorities as well as the union authorities, Government of India.
Whether pleadings are complete?
No, my lord, I was requested by the council for respondent number 9, JICA council. She was on leg. She requests me to pay 6 weeks time for filing affidavit, my lord. Mary L. Kyangte.
Respondent number 9.
Respondent number 9 in item number 5.
Her name is Namita Chadda.
Savita Sarna. Also.
You are?
I'm Savita Sarna, Your Lordship.
Appearing for respondent number 9.
Yes, respondent number 9 along with my colleague who's present in the court.
Okay. Then you can make your submission yourself.
Yes.
Thank you, Your Lordship. Your Lordship, as JICA has been recently integrated.
You are praying for some time.
Yes, Your Lordship. We
How
are
much?
praying some time for filing the counter affidavit. We have collected all the necessary information because it was like a project information we have received. Lot of information was collected from Japan and other respondents. We have inspected the file, but now we need to prepare the counter affidavit. So allow us, Your Lordship, if 6 weeks time is given, yeah,
Yes.
I will be much obliged.
Any objection?
No objection.
Heard Mr. C. Lalram Zuava, Learned Senior Counsel, assisted by Mr. Stephen Lalbuat Saiha, Learned Counsel for the petitioners. Common order in all cases. Who is representing the state? Miss Lal. Miss Lal Nun Lui appears for the state respondent.
My
Miss-
lord, I'm for respondent number 5, Union of India.
I forgot. Ms. Zairam Sankui appears for Central Government Standing Council appears for respondent number 5. Ms. Savita Sarna, Learned Council for respondent number 9, appears through video conferencing and prays for 6 weeks' time to file affidavit in opposition. Anybody else?
I'm representing the NHIDCL, my lord.
Mr. Samuel Vanlal Shiata appears for respondent number?
My lord, it's different in different repetitions, my lord. Standing
Okay.
counsel for NHIDCL and all the MPs.
Appear for NHIDCL. And Ms. Dinari T. Azu
I'm
appears,
appearing for the item number 8, petitioners.
appears for petitioners in
WPC number 71.
WPC number
71 of 2023.
71/2023.
Item number.
Anybody else?
Lordship, I'm appearing for the petitioners in item number 5, WPC 55 of 2023.
Miss
Mary
what's-
Lilram Hete.
Mary?
Yes, Your Lordship.
Mary Lal Rem Katie.
Lilram Hete, yes.
Lal?
Lilram Hete.
Lalram Heti
Yes, Your Lordship.
appears for petitioner in item number 55.
Item
no,
number
no, sorry,
5.
WPC 55/2023.
Lordship, I am appearing for the petitioners in item number 13, 14, 15, 16, and 18.
Mr. What's your name?
Michael Patrol, Lordship.
Michael.
Item number 13 to 16 and 18.
WPC number dibo, huh? Item number Michael, what's your full name?
Michael Patrol.
Give in writing your title.
Yes.
Appears for item number 13, 14, 15 and 16.
And 18.
And 18. Anybody else?
My lord, we are for the petitioner in item number 6, 7, 9, 10 and then 11.
Also Mr. What's your name?
On behalf of my senior Zoram Chana,
What is your name?
Samuel Lompuya.
You have to repeat your name.
Samuel Lompuya.
Samuel.
Yes, my lord.
Appearing for Mr. Zoram Chana in Learned Council for
Petitioner.
petitioner in item number
6, 7, 9, 10 and 11.
6, 7, 9, 10 and 11.
Yes.
Stop. The prayer made by Learned Council for Zyco, Miss Savita Sarna, is allowed. Let this matter be listed after 6 weeks.
Obliged, my lord.
Item number 19.
May it please Your Lordship?
Yes.
My Lord, this is an appeal against judgment and an impugned judgment and order passing a declaratory suit in which the respondent was declared as the rightful owner of LSC, an immovable property.
Why it
over
has
5
come up
years.
in orders column?
My Lord, as per the last court order, service of notice has been completed and copies of my appeal memo is also received by the respondents.
Whether trial court records have been received?
My Lord, it seems that the counsel for the respondent number 1 is on his legs in another court.
No, the trial court records were not called for.
NCR has already arrived, my lord.
It is there. Then we'll fix the matter for hearing.
Yes, my lord.
Yes, my lord.
Heard, Miss, what's her name?
One more thing, my lord, if I may intervene. At page 19, if I may take your lordship to page 19, I have an interim prayer for suspension of the operation of the impugned judgment in order.
What was the order?
The order is that the respondent number 1 was declared as the rightful owner of the immovable property, and in pursuance to that, he is under the process of mutation of the LSC in his name. So,
No, but this appeal is under what provision?
Section 17(2)(b) of the Mizoram Civil Courts Act, read with Section 96 of CPC.
So you don't have to file a separate interlocutory application for interim relief. I don't know, you have to answer. Is there any separate provision like
As per my
order
knowledge, my
form?
lord, there is no need for a separate application for interim order.
It is required in RFA. Order for, you have CPC with you.
Yes, my lord, but my senior is on his legs in another court, and that CPC is in the back. I was having it with me in the morning.
You have to file a separate. Go through Order 41, Rule 5. Whether you have to file an application under Order 41, Rule 5, a separate application.
Yes, my lord.
You filed it.
Okay, my lord.
Heard. Okay. Heard, Miss, what is her name?
H. Lero Sangi.
H. Lalro Sangi,
Yes, yes, my lord.
learned counsel for the appellant. Also heard Mr. Ricky
J.H. Ricky Lal Rotfella.
J.H. Ricky Lal Rotfella, appearing for respondent number 1, as well as Miss Caroline, appearing
Yes.
for
Respondent number 2 to 4.
2 to 4. It appears that the records of trial court have been received, and there are only 4 respondents.
Yes.
And the service of notice on all the respondents is complete. Hence, this case is ready for hearing. List this matter for hearing in its due course. The learned counsel for the appellant has submitted that the appellant has also prayed for an interim relief of stay on the execution of the impugned judgment during the pendency of this civil appeal, pendency of this regular first appeal. However, no separate interlocutory application has been filed for the same. This court is of considered opinion that a separate interlocutory application and a prayer under Order 41, Rule 5 of the code of civil procedure has to be made for any stay by the appellate court, which has not been made in this case. The appellant may do the needful accordingly, list accordingly in due course. You may
My lord,
file
If
in-
I may be allowed to just ask just one question. There is no execution case filed by the respondent.
then there is no necessity of stay.
Stay, at page 19, if my lord turn to page 19. My exact word is to suspend the operation of the impugned judgment and order.
Where is the provision?
I apologize, my lord, I could not produce any provision today.
No, you take time, you come up next time prepared.
Yes.
Don't seek apology. You take time, that next time I will show you the provision.
Yes.
I'll give that time. Go through.
Yes, my lord.
Okay, list accordingly. You can, if you find that they go for execution because there is no stay, they may at any time go for execution.
Yes.
You can come up with an interlocutory application.
Obliged, Item 20.
May please, Your Lordship. My Lord, lower court records have been received, my Lord.
Received?
And, yes. And at this stage, I think paper book is required, my Lord.
Okay, otherwise, the parties have appeared, you are appearing for respondents.
Yeah, only for respondent number 1, my Lord.
All have appeared. Okay. Heard.
And one more thing, my Lord. In the last court date on 27/3, it was my name. I have made a submission that my name has not been reflected in the cause list, my Lord. And till date, it was not reflected.
What is your name?
Lal Biak Nungat Namte, my Lord. Lal Biak Nungat Namte.
Spelling?
LALBIAKNUNGA HNAMTE.
BIAKNUNGA. Yes.
HNAMTE. Lal Biak Nungat Namte.
Lal Biak Nu.
Namte.
Very difficult to pronounce.
It might be difficult, but
Therefore, they are not reflecting your name.
yes, my Lord. I haven't seen till date. And
Heard, Miss, what is your name?
Latlan Louis. My name is not in the course list
Not-
yet.
You also give your name. Learned Counsel for the appellant. Also heard Mr. Lal Biak. Take the name, complete name. Learned Counsel for respondent number 1, 2, 4.
No, only for respondent number 1, my Lord.
For respondent number
Number 1 only.
None has appeared. Whether service is complete in respect of those respondents.
We have filed the Labana on 14/1/2025, my lord.
Oh no, not yet. Though the notices were issued to respondent number 2 to 4, however, office note dated 16/6/2025 shows that no service report has been received in respect of the notices issued to respondent number 2 to 4. await further for service report in respect of respondent number 2 to 4. We'll await. Let this matter be listed after 2 weeks. The name of Mr. It appears that in spite of the specific direction of this court to reflect the name of learned counsel for the
Respondent number 1.
respondent number 1, namely Mr. Lal Biak, complete name in the cause list, same has not yet been done. Registry to do the needful and reflect the name of Mr. Lal Biak Nungha in the cause list henceforth. You give your
Yes, my lord.
list accordingly after 2 weeks.
Grateful, my lord.
Hearing item number 5.
My lord, this is second appeal against the first appellate court order dated.
Just a minute. Please. This you keep with the records of orders which I have reserved for delivery in chamber. Yes.
This is the second appeal against the first appellate court order dated.
This is item number
5, part
Five.
2.
What is your name?
Aldrin Lalong Zwala.
Aldrin.
Yes, my lord.
Okay. Yes. Yes, please.
Yes. And my lord, substantial question of law was formulated on 23rd 11 2022.
23rd 11 2022. Whether the judgment and order dated so and so.
And there are two substantial questions of law formulated, my lord.
For verse 16.3.
Number one is whether the judgment and order dated 3/4/2018 passed by the first appellate court in allowing regular first appeal filed by the instant plaintiff respondent number 1 is perverse and not based on evidence on record. My lord, because the first appellate court did not go into the merit of the case based on the evidence. He has come into a conclusion by using his own mind, not on the basis of the evidence.
Okay.
And number 2 is whether the first appellate court had correctly applied section 16(3) of the Contract Act 1872 to the facts of the case, especially when it has not been pleaded by the plaintiff. So, my lord, the case is that...
Just 1 minute, Your Lordship. This, this formulation, it's very short, and in entirety, the issue is whether the plaintiff and the respondent has agreement or not. That is the issue. That is not made as a substantial question of law here. The thing is that the respondent alleged that in accordance with the agreement, I have changed my name in the LSC. The LSC is, one LSC is there. The owner is the respondent herein. And the appellant said that you have agreement. That's why I changed my, to my name, that the particular LSC. However, the plaintiff responding hearing said that I have not made any agreement. I have not signed any application. So that is the case. So here, substantial question of law is a very, it's a...
No, that is the substantial question, whether the judgment is perverse or not.
Yes, perverse or not.
Whether it has taken into consideration
Yes, my lord.
the evidence on record.
Yes. And the agreement is not there at all.
My
Even
lord,
though
that is not an agreement. The case of
said that
the case of the respondent as a plaintiff said that he had made a will in favor of the appellant.
during the lifetime of the...
and later on,
Not in this way.
Yes, yes. During the lifetime
No,
of...
no, you are raising some preliminary objections.
Yes.
Or otherwise you will get your chance.
Yeah,
once
yeah, I know. Whether it's required to add substantial question of law or not.
That is not a substantial question of law, what you are proposing.
Yeah.
Whether there is an agreement or not,
Mm.
it apparently is a question of fact.
Yes.
Whether something exists or not
Yes.
cannot be a question of law.
Mhm.
It is a question of fact.
Yes.
Maybe disputed question of fact.
Yes.
Which we cannot go into in this second appeal.
Yes.
We can look into whether the judgment is perverse or not.
Yes, perverse.
If it is without
It's a very weight, perverse or not. I understand
it
that.
is
It's
wide.
very weight.
Wide.
You can be included in that also.
Yes.
Yes.
The court
It's
can
okay.
frame
It's okay.
If there is,
Yeah.
if suppose there is no evidence
Mm.
that there is any agreement,
Yes. Yeah,
Then-
it can be included. Yeah, I understand that.
yes.
If she had proposed it, my lord, it's up to the court, my lord. So, my lord, my case is that as a respondent, as a plaintiff, he had a property covered by LSC 932 of 1979
LSC,
at page 9
page
9 of the paper book. And his name is...
page 9 of the paper book.
Yes, my lord.
This LSC was in favor of whom?
The respondent,
Sole respondent.
sole respondent. And the respondent was died during the pendency of the appeal, first appeal, and he was represented by my cousin, my first cousin.
His legal heirs.
Yes.
Okay.
That was not challenged at that time. If it was challenged, there would be no other case, my lord. So we have not challenged that in the trial, in the first appellate court. So anyway, let it be, let it remain the same. He was represented by Lalding Liana. The petitioner name, the appellant name is Lalding Liani, and now he was represented by Lalding Liana. The only difference in his own name is if it ends with I, means a lady. If it ends with a means a gentleman.
No, how it is relevant that that the respondent is represented by your first cousin?
No, there's no...
First thing, they all are related.
We are all relative, my lord.
Thing is that plaintiff respondent hearing is the owner of the land. And now the appellant is plaintiff's brother's
younger
daughter.
brother's daughter.
Okay.
And the other, after
Legal
the death of the
representative-
plaintiff, Biak Vela, after the death of Biak Vela, one Lalding Liana was represented.
That was his brother.
His brother's son.
I'm his brother's daughter.
So litigation is within family.
Family.
Family matters.
Okay.
And then, my lord, he said in the trial court, he said that he had made a will at page 54.
Before you go into the will, what is the gist of the case?
The gist of the case is that, my lord, the respondent had landed property and then he had given it to me as a gift in a prescribed form. Because in Mizoram, there is a prescribed form made by the revenue.
Let it come from the start, how Lalbiak Vela, plaintiff has filed a case. From that you have to start.
What is the plaintiff's case?
The plaintiff case is that, my lord, he had made a will.
No, it's not start from that.
No, he had made a will, the respondent had made a will, and then during his lifetime, he had changed the will and made it the present legal representative as the owner of the land in his will. And at the same time, our case is that it
Now,
was
why he came to court? What made him?
without his knowledge and knowing that I had changed the property into my name.
That
Which
is
was
his
the-
allegation.
Yes, that is his allegation.
And what relief he is seeking?
He's claiming that, my lord, page 6. Page 5 is the prayer.
Yes.
In the that the issuance of LLC number so and so in respect of the suit land in favor of the defendant number 4. Defendant number 4 is the present appellant.
Appellant, okay.
Legal, void and invalid.
Okay.
And at page 6, that the plaintiff is the owner of the suit land and a building under LLC number 932 of 1979, dated 18/9.
Okay, these two main reliefs.
Yes.
Be-
Yes,
the,
these two.
Your claim over the building which is constructed over the land as
And
well
the-
as cancellation of the LSC.
Yes, my lord.
Okay. Then what happened? Now what is your case?
My case is that, my lord, that at number page 29, starting from 28 and may I read 29. Paragraph number 10. May I read, my lord?
Yes.
That the contents of para number 3 of the plaintiff is ridiculous, totally false and completely
No,
denied.
you tell me in gist what is your case.
My case is that, my lord, I did not apply through by using the will which was made by the respondent. The fact is that I had changed my name by giving the respondent had given me a gift in a prescribed form in which where all the families are gathering. And then by using that gift paper, then I submitted to the revenue authorities, and the revenue authorities had mutuated in my name.
Okay. It is not on the basis of
Not on the basis of the will.
will.
No.
Okay.
So that was all. These are in the evidence, and which has not been dwelt into by the first appellate court.
What is the observation of the trial court regarding your claim? How it rejected?
At page 147, my lord. My Lord, may I read from paragraph 4, or paragraph serial number 1, page 147, my Lord.
Yes.
This is a suit filed by Sri Lalbir Vela against the defendant for declaration that the land and building under LSC number 392 of 1979, which was renumbered as LSC number 26 of 2004, issued in the name of the defendant number 4. Defendant number 4 is the present appellant, as illegal, void and invalid, and for declaring that the plaintiff to be the owner of the suit, land and building. Unfortunately, Sri Lalbir Vela died on 16/6/2011 during the pendency of the suit, and the deceased was substituted by Lalding Liana, white order dated 19/8/2011. The fact of the case of the plaintiff is a senior citizen and a permanent resident of Hulikon, Aizawl, Mizoram, and the owner of plot, land and building covered by LSC number 932 of 1979, dated 18/9/1981, renumbered as LSC 26 of 2004, dated 10/12/2004, located at Hulikon, Aizawl, and the defendant number 4 is the daughter of the plaintiff's elder brother. The plaintiff came to learn that the Revenue Authority had transferred the ownership of his said land and building covered by LSC number 392 of 1979 in favor of the defendant number 4 without his knowledge and consent. Accordingly, the plaintiff submitted complaint to the revenue authorities against the transfer of ownership of his land in favor of the defendant number 4. The plaintiff served notice dated 12/9/2004 under 80 CPC through his counsel to his advocate upon the revenue authorities due to long pendency of the dispute, claiming relief in the nature of disposal of dispute and cancellation of the transfer of ownership of the sued land of the plaintiff to the defendant number 4. However, the revenue authorities did not make necessary amends till that, hence the instant suit. On the other hand, government submitted their written statement stating that attempt was made to make amicable settlement between the plaintiff and the private defendants apart from raising usual objection. However, the plaintiff approached the law court during the pendency of the matter at the secretariat level that the defendant number 4, that is the appellant, has vehemently contested against the present suit by filing her written statement through her counsel. Apart from raising strong objections against the instant suit, the defendant number 4 stated amongst others that the land and building covered by LSC number 932 of 79 was transferred in the name of defendant with full consent and knowledge of the plaintiff, as the plaintiff prescribed his hand in the application for transfer of ownership before reliable witness and family gathering at the quarters of Sri Lalmachuana, ITS, Khatla, Aizawl. On the basis of the pleading of both parties, the following legal issues were framed. Number 1, whether the suit is barred by limitation doctrine, estoppel acquaintances or not. Number 2, whether the transfer of ownership of the land and building under LSC number 932 of 1979 from the plaintiff to the defendant number 4 is illegal, void, and invalid or not, and if so, whether such transfer mutation is liable to cancel or not. Number 2, whether the plaintiff is entitled to relief claim, and if so, to what extent. So now may I take you to page 153, my lord.
Yes.
Findings. Whether the suit is based by limitation, doctrine, and estoppel and acquaintances. I may not.
You can skip that.
Yes. Number 2. Whether the transfer of ownership of land and building under LSC number 932 of 1979 from the plaintiff to defendant number 5 is illegal, void, and invalid or not, and if so, whether such transfer mutuation is liable to cancel or not. The plaintiff deposed on oath that he came to know that his LSC number 932 of 1979 was renumbered as LSC number 26 of 2004, and it was mutuated in the favor of the defendant number 4 without his knowledge and consent. The plaintiff submitted a complaint to the revenue authorities thrice, and the defendant number 4 was issued notice to appear personally and also to submit the original LSC, and the matter could not be resolved by the revenue authorities. The plaintiff, as a witness on his cross-examination by the counsel of the defendant number 4, had admitted that defendant number 4 and her husband had somehow looked after him by spending some amount of money, sometimes after the year 1995. However, it was difficult for him to access the exact amount of money they spent in that connection. Even the government advocate had cross-examined the plaintiff as witness, and the exact words of the cross-examination part may be produced as follows. It is not a fact that I did not put my signature in any application form for transfer of my said LSC in the name of defendant number 4. The actual meaning of the said cross-examination aforementioned is that the plaintiff in his cross-examination admitted that he put his signature in the application form for transfer of his said LSC in the name of defendant number 4. On the other hand, the defendant number 4 contended that ownership of the land and building covered by LSC 932 of 1973 was transferred with the full consent and knowledge of the plaintiff, as the plaintiff subscribed his hand in the application form for transfer of ownership before reliable witnesses and family gathering at the quarters of Srilal Machwana ITS Khatla, Aizawl. The defendant number 4 examined herself as a witness and exhibited 8 documents without any objection. Further, the defendant number 4 produced Nuzoni, 80 years of age, as defendant number 3, who is the cousin sister of the plaintiff, before the court, and deposed on oath as follows. That was written in Mizo vernacular, my lord. So I skip that. My lord, all these are there in the paper book, my lord. Whatever in a Mizo vernacular, if necessary, I may read out later on, my lord. It was there in the paper book, my lord.
Where is the translation?
Yes, my lord, at page page 109, 109.
Okay. No, we are not going to that.
Okay.
You show me which evidence the court did not consider.
Yes.
Directly go to that.
Yes. Then, my lord, let me go to the first appellate court judgment.
Yes.
Because all these issues were in my favor, my lord.
We'll have
after lunch, my lord.
After lunch. After lunch, we'll continue.
Yes, my lord.
Both of you may have to give bullet points of your argument in writing, in 2 sheets. it will be over by after, how much time will you take?
My lord, you will be here next week, so my lord,
No. Today, how much time will you take to finish? Half an hour? 1 hour?
around 1 hour.
1 hour. How much you will take? Point is very short.
It should come from the beginning because this is the impugn first appellate order.
Wherever
yes, you have to start from the beginning.
You fill up the gaps.
Yeah, fill up the gaps.
So you take 1 hour.
Yeah,
Today we'll
it
finish.
will take 1 hour.
We'll finish the hearing in the post-lunch session. Then both of you have to submit gist of your argument. 2 sheets or 3 sheets paper. One sheet, 2 sheet paper.
Right. We'll do that.
Okay. We'll assemble after lunch.